Good evening.
Some sound going. Good evening, Professor Chirwa. How are you?
I'm fine, and you?
I'm okay. I'm a bit nervous. I think it's easier to preside over a case and deliver a judgment.
Okay, yeah, I understand. It's nice to have you, and we appreciate that you could save time to give this lecture. Truly appreciate it.
It's an honor for me. Thank you.
Welcome, colleagues within the faculty and the university, alumni, and everybody who has joined this event. Special welcome to our speaker, Justice Jody Kollapen, and special welcome also to the Rabinowitz family, in particular, Mr. Benny Rabinowitz and his daughters, Susan and Leslie. The Annual Rabinowitz visitorship, of which this lecture forms part, was established by Mr. Benny Rabinowitz and his wife Shiley in 2009. The visitorship is designed to have a focus on law, democracy, equality, and justice, with the aim of bringing leading lawyers, eminent figures in the legal profession, to participate in the intellectual life of the faculty, normally over 3 to 4 days, which this time we are unable to do due to the limitations posed by the pandemic. But we are very pleased today that at least we can host the lecture, all due to the fact that Justice Kollapen was generous enough to say that he would be willing to do it now, and perhaps we can do the visitorship later when the conditions allow. The Rabinowitz, Mr. Rabinowitz is a Cape Town-based entrepreneur and a philanthropist, who has spent his life committed to the cause of social justice in South Africa, and has used his experience and success to promote constructive engagement on these issues. So apart from his involvement in many organizations and membership of boards of many organizations, he has also been actively involved in community issues and has led campaigns, for example, to stop the Udekral and Sea Point Promenade developments. Over the last 11 years, this annual lecture has brought to UCT and the faculty in particular key figures in the field of law, including Justice Edwin Cameron, Justice Sotomayor of the U.S. Supreme Court, Professor Blake Morant from the USA as well, Lord Lenny Hoffman, and Sir Geoffrey Joel, Queen's Counsel. And this year we're very pleased to have another eminent legal jurist in the name of Justice Jody Kollapen, who will be talking today about 25 years of the South African Constitution. Jody Kollapen is a judge of the North Gauteng High Court, based in Pretoria, who has served as acting justice in the Constitutional Court of South Africa. He qualified as an attorney and was admitted in 1981, practiced in Pretoria for many years, focusing on public interest litigation. He joined the Lawyers for Human Rights in 1992 and became its national director in 1994. He was appointed to the South African Human Rights Commission in 1996 and became its chairperson in 2002. And served in that capacity until 2009. In 2013, he was appointed Deputy Chair of the South African Law Reform Commission and became the Chair of the said commission in 2016. He has served on many boards of NGOs and was awarded an honorary doctorate by the Durban University of Technology, as well as the Citizens Excellence Award by the Mayor of Tshwane for his contribution to human rights. With these brief opening remarks, I welcome Justice Kollapen to give the lecture, after which there will be some time for questions and answers. You can note your questions in the chat as Justice Kollapen gives the lecture, and then we'll surface those questions to him during the discussion time. Justice Kollapen, I hand over to you. Thank you very much.
Thank you, Professor Chirwa, and thank you for that warm welcome and introduction. I'd like to formally thank the University of Cape Town for extending this invitation to me and for inviting me to become the next visiting recipient of the visitorship established by Mr. Judge Rabinowitz. I'm honored and humbled to join such an esteemed list of previous visitors who rank amongst the best in this country and internationally. I'd like to just take a moment to recognize the work and the commitment of Mr. Judge Rabinowitz and, may I say, his family. That the work of Mr. Rabinowitz during his life and the work that he continues to do, I think, reminds us all that all of us can make a difference, some in small measure and some in large measure, to the lives of the people of our country. And I think his example and his commitment serves as an inspiration to all of us. I salute you, Mr. Rabinowitz. The topic I want to speak to is 25 years of the Constitution and where to from here. This, in the 25th year of our Constitution, comes at a difficult time. We are in the second year of grappling with the COVID-19 pandemic. It has redefined how we live. Maybe it has allowed us to take more seriously and cherish the freedoms we have, not to take each other for granted, and to recognize the values of solidarity, and to recognize that despite our differences, we do share a common humanity. And we saw much of this during the last 2 years, how we were able as South Africans to reach out to each other and to attempt to improve the lives of each other. We learned to take more seriously the plight of others as we witnessed firsthand the devastating effect the virus had, especially on the poor. And at the same time, we recognized our common vulnerability in the face of a pandemic that did not discriminate between class, gender, race, or otherwise. It has brought us together as a people, and one hopes that the lessons we have learned will endure. It's also been a year of intense conflict and contestation, political and otherwise. The July riots, both its genesis as well as its manifestation and its aftermath, leave us with more difficult questions about the nature of our society and the fragility of the democracy that is in many respects still in its early years. And so let's rewind to 25 years. In May 1996, former President Nelson Mandela, on the passing of the vote in Parliament to bring into force the Constitution that governs our lives now, said, and I quote, "The brief seconds when the majority of the honourable members quietly assented to the new basic law of the land have captured in a fleeting moment the centuries of history that South African people have endured in search of a better future. And so it has come to pass today that South Africa undergoes her rebirth, cleansed of a horrible past, matured from a tentative beginning, and reaching out to a future with confidence. While the ushering in of a new constitutional order that evidenced an unconditional rejection of the past and a commitment to a fundamentally and qualitatively different future was always going to be historic, few of us imagined how dominant a place the Constitution would come to occupy in virtually all facets of our lives, from the overtly political to the intensely personal, in commerce, trade and industry, in sport and leisure, and indeed in the collective and individual self-determination that occurs all the time. The Constitution has been a constant. Of course, the scope of its impact will be strenuously debated and often difficult to quantify, and will invariably be shaped by the vantage point of the reviewer. For many, the Constitution has truly been the source and the foundation of a better life, one characterized by respect for their worth and dignity, and one that has enabled them to reach their potential, as the preamble to the Constitution so boldly proclaims. For many others, however, the Constitution remains an illusion on the horizon, so near and yet so far. They impatiently wait for its promise of a better life to be fulfilled. But irrespective of the vantage point one holds, the transition to democracy and the adoption of this Constitution remains significant for all of South Africa. For the first time in our tortured history, were we able to put in place a legal order that was inclusive of all our people and that recognized our unity, even amidst our bewildering diversity. The vision of the Constitution was to seek to bind us together in recognition of our common humanity and to set us on a path to a future that would have been so different from the one we sought to leave behind. And so I'm deeply disappointed when I hear views expressed that the South Africa that existed pre-1994 was somehow a better place than the South Africa of the present. That assertion is deeply insulting to the millions of people who lived under the yoke of apartheid, their humanity and their dignity negated by a cruel system that was properly described to be a crime against humanity. So much so then for those who think it is possible to fight for a better past. In this context, I'm also acutely aware, however, that many people, though, have still to experience the new order and are less excited and passionate about it than perhaps you and I, and those who have benefited from its promise. I recall a visit many years ago when I was the chair of the Human Rights Commission to a village called Gapasha, deep in Sekhukhune. The village was in a state of great neglect. Very few services were available, unemployment was high, and the faces of the villagers were etched with a deep sense of disappointment and failed expectation. After I'd spoken to them about the Constitution and the Bill of Rights, an old man rose to welcome my remarks, but also to remind me that maybe, and perhaps just maybe, the passion with which I spoke was somehow triggered by the reality that this Constitution, whose virtues I extolled, had worked so well for me, which was quite evident to all, he remarked. He promised to show the same passion for the Constitution as I did, when one day it worked for him and his community. I thought that his words and his remarks were an honest but absolutely fair observation coming from his vantage point. And so, while the topic, the 25 years of the Constitution, will no doubt provoke different responses, it'll probably be fair to perhaps just for a moment assess what we sought to achieve and where we were 25 years ago. Long before the negotiations of the early 90s commenced, it was obvious that revolutionary change on the back of an armed struggle, coupled with an internal resistance and ungovernability, was unlikely, at least in the short term, to see a change in government. That change would come through negotiation. It would encompass a process that would be more evolutionary rather than revolutionary. It would seek to appease those who held fears for the future, while at the same time, it will assure others that their hopes for a better future would be met. A difficult balance to strike between the competing considerations of fear and hope. And former President Thabo Mbeki, addressing the National Conference on Racism hosted by the South African Human Rights Commission in 2000, said the following, and I quote, "If white South Africa is fearful of the future because of what it might lose, Black South Africa looks forward to the future because of what it will gain." And one wonders to what extent these twin drivers of fear and hope still characterize much of our national discourse today. What is clear, however, is that the drafters of the Constitution understood the elements of fear and hope and attempted to respond to it through two imperatives. And that commitment to respond to the fears and the hopes of millions of our people is found in the twin imperatives of reconciliation and transformation. The one, reconciliation, would speak to the fears that were held, some validly, I would say, while the other to the hopes that were held, also equally valid and legitimate. Again, how we have fared in advancing these objectives remain a matter of considerable contestation. And clearly, the task of building a new society was enormous. The vision for the future was bold and ambitious, while the deficits were deep and damaging. They existed in the deep poverty and inequality that was and continues to be so characteristic of South Africa. They existed in the deep distrust, largely along racial lines between our people, based largely on our ignorance of each other and our forced separation for so long. And so deeply damaged society and its people collectively set out on a path to do something quite extraordinary. And what they sought to achieve is captured quite eloquently in the words and the text of the Constitution. What the Constitution does is to set out a set of clear markers that would define the nature of the constitutional state that had come to be born. And it was largely in terms of our expectations of ourselves and our government, rather than the reality at the time. They included in the preamble a recognition that South Africa belongs to all who live in it, that the Constitution was adopted as the supreme law in order to establish a society based on democratic values, social justice, and fundamental human rights, that it would lay the foundations of a democratic and open society based on the will of the people, and that it would improve the quality of life of all citizens and free the potential of each person. Even when I read it today, this is an amazing text, formulated so simply, yet so powerfully and profoundly, that all of us can relate to it. We can see our future and that of our children and grandchildren woven into the fabric of our Constitution. It captures our hopes, our fears, our insecurities, and our dreams. It proudly proclaims the people we aspire to be. And we may ask, have we become that country? Have we become those people that it speaks to? I'm not sure, perhaps not yet. There are in turn various provisions of the Constitution that seek to give content to these aspirations. And I'll not mention all of them, but gently they will include provisions that provide for open, accountable, and responsive government, that reaffirms the supremacy of the Constitution, and that guarantees fundamental human rights and freedoms, including social, economic rights, and a strong commitment to equality, with the recognition of the need for corrective measures or affirmative actions to deal with the injustice of the past. However, as lawyers and as non-lawyers, we all recognize that the Constitution was never intended to be self-executing. While textually it ranks as one of the best in the world, but for its provisions to transcend the paper it is inscribed on and to be converted into reality requires people and institutions, all who share common fidelity to the Constitution, to act in unison. Simply put, the Constitution thrives or withers away depending on the context and the enabling environment within which it exists. I've heard it said that democracy is the oxygen of constitutionalism. And so it is difficult to conceive of even the most vaunted constitution thriving in a non-democratic context, while on the other hand, a constitution with modest objectives will likely prosper in a democratic environment. Accordingly, a constitution on its own can never be a barometer of the state of democracy. At best, it represents a signaling, an important signaling at that, of the intent of those who've adopted it. Ours was no different. It was a statement of intent, brave, far-reaching, ambitious, but still no more than a statement of intent. And so if democracy, as it were, is a precondition to a healthy constitutional state, what then are the features of that democracy within which a constitution either thrives or withers? And I can do no better than to refer to a lecture delivered by Nobel laureate Amartya Sen at Rhodes University in 2004, when, in speaking about democracy, its roots, its values, and its origins, he described what he called the two perspectives of democracy. The first is what he termed the public ballot perspective, and the second is what he termed the public reasoning perspective of democracy. The public ballot perspective is largely self-explanatory. It deals with the adequacy of the public ballot, the freedom to vote, the integrity of the ballot, and the integrity of the assessment of the ballot. The second perspective, the public reasoning perspective, is what he described as the opportunity of participatory reasoning and public decision making. He says that the democratic claim of a political order has to be judged by its commitment to protect as well as to respond to public reasoning. Voting and balloting are, in this perspective, just one part of a much larger story. What Sen has in mind was described as government by discussion, where government is responsive to public reasoning. And clearly one may say that the terms and the provisions of our constitution capture this. And yes, I would agree they do, both in the participatory nature of the system of government that it introduces, coming with it the opportunities and rights of citizens to participate in policymaking, lawmaking, and other processes. Of course, one may then validly ask, if one uses this as the framework within which to assess the state of our democracy, how have we done? Over the past 27 years or so, the integrity of the ballot has endured considerably well, and free and fair elections have become a significant and regular feature of our democratic order. What must be of concern, however, is the declining number of citizens who use the ballot. The recent turnout in the municipal elections put the figure at approximately 44%. But when one has regard to the large number of people who have not registered as voters, even though they are eligible to vote, that number is reduced to 30% of eligible voters. That must be a cause of concern, particularly in a country where citizens seek so much of their government, and in particular where we have such a sophisticated form of government existing at the national level, the provincial level, the local level, and even beyond that. So while at the formal level we have secured the public ballot, I'm not sure in terms of the numbers of people who actively participate in elections, whether that's a true reflection of a public that is keen and eager to use the ballot as an expression of their political will and their political choices. Equally, when one considers what Sen described as the public reasoning perspective of democracy, can we say that participatory reasoning and the ability to respond to such reasoning has become a feature of our democracy? I'm not sure. Despite quite a sophisticated system of government that I've described, the number of and the intensity of public protest directed in the main at government must be an indicator that existing channels of democratic participation are not working optimally or at all. Of course, the right to protest is constitutionally guaranteed, but when that becomes the most effective way of being heard in a democratic system with so many layers of government, then it too must be a cause of concern. And let me illustrate the point by offering the following real-life example. The provision of textbooks as part of necessary teaching materials has always been a part of government policy. One must then ask why it was necessary for parents in a system of participatory democracy and with many of the tiers of government to go to court to secure an order to compel government to provide textbooks in accordance with their own policy. You would have thought that when the problem of the absence of textbooks arose, a locally elected councillor would become aware of the matter, raise it with the provincial education department, and the matter would be resolved without the need to resort to adversarial litigation. That is, after all, what participatory democracy is, being responsive to public reasoning, and that is what it should have achieved. And so it must then become evident that in the absence of what Sen describes as the public reasoning perspective of democracy, the Constitution may lack the enabling environment necessary for its proper fulfillment and its ability to deliver on its promises will always be constrained. And if the past 27 years have demonstrated anything, it is that we cannot take comfort only in the strength of the text of our Constitution and the legislation that has flowed from it. Important as it is, and equally important as the impressive institutional framework that has been put in place is, what is often lacking is the consciousness of what the Constitution requires, of public duty, public service, of an ability to feel the heartbeat of a nation, to understand its hopes and aspirations, its fears and uncertainties, and to be able to effectively respond to them. In this regard, we should take heed from the words of Professor Thomas Pocher, a global expert on poverty and writing in his book, Freedom from Poverty as a Human Right, when he says, and I quote, "Human rights instruments have become a substitute for real progress. Great battles are won and glorious victories. Great battles are fought and glorious victories are won over rhetorical details that in the end make little difference in the lives of real people." You may say that's a harsh assessment of human rights instruments, but I imagine for the man in the village in Khapasha and for the millions of people who live in poverty and in deep neglect, they may feel that way about the human rights instruments that are meant to regulate their lives. And so it's against that background and context that I wish to examine three features, really, of the challenges we started out with in 1994. I'm not suggesting that they are the only ones, but they appear to be at least among some of the most significant ones. Firstly, the idea of a united South Africa, one that was able to heal the divisions of the past, an inclusive and united nation. That's what the Constitution asked of us. In this regard, Archbishop Tutu's Rainbow Nation description of our people and the image of President Mandela standing proudly alongside rugby captain Francois Pienaar, holding aloft the Webb Ellis Trophy, remains inspirational. In reality, however, and despite the groundbreaking elections of 1994, we were then, and to some extent, still are a people who do not know each other. We still remain suspicious and distrustful of each other, and under circumstances where our shameful past still stands like a colossus between us. While the work of the Truth and Reconciliation Commission was important in uncovering some of that past, it was in the main focused on the role of law enforcement and security agencies and the excesses they were responsible for: police, government, defense force. There was really no real opportunity for ordinary South Africans to engage in discussion as to what the past meant for them, how they understood it, and the kind of commitments they would make to each other to ensure the future would be better and different. In many respects, we simply went our own way, and reconciliation was largely confined to gestures of forgiveness and some limited coming together of perpetrator and victim. In the work I've done, I've come across many people from all races, all different cultural persuasions, who seek to have this opportunity to truly and honestly engage with each other about what the past has meant. And I don't accept the argument that the past has been dealt with and we should leave it there. I was invited some years ago to a conference in Vienna in Austria, where current generations of young people in Austria still debate what happened in their country and the collusion between the Austrian people and Nazi Germany in the unfolding of the Holocaust. It is something that impacts on their psyche and something that impacts on their identity as a people, and so it stays forever. I happened to meet Simon Wiesenthal at that same conference, who was simply aghast that as South Africans, we had chosen to forgive the perpetrators of gross human rights violations. I could understand that it was difficult for someone who had hunted perpetrators of the Holocaust all of his life to be able to reconcile himself to a concept such as reconciliation, but that was the choice we'd made. And so today, the question of our past, of race and its role, still remains deeply contested and unresolved. That we have to debate Black Lives Matter says it all. Of course, all lives matter. But if South Africans do not understand or even attempt to understand the history and context within which the Black Lives Matter movement was born, then we will forever remain insensitive to what happened in our own country for so long. And so we do not talk about racism, but it confronts us in different forms and guises all the time. The Cricket South Africa hearings into transformation currently being held, the Human Rights Commission inquiry into the Phoenix killings all give us a glimpse into and of the current manifestation of racism, but it appears we steadfastly avoid any real and meaningful discussion about it. There is no anti-racism campaign in a country that has lived with racism for so long. There are hardly non-governmental organizations that focus on anti-racism work and programs. There are a few, but for a country such as ours with its history, one would have hoped and expected more, in particular where we have a rich community of NGOs focusing on important matters such as the rights of children, of women, of prisoners, of LGBTQI, of non-nationals, etc. And so dealing with racism will require, at least as a starting point, the recognition that we have not done much on that score. But there's hope for the future, and I want to share a little anecdote that maybe the next generation may see these issues differently from ours. I have a granddaughter who's 10, and she goes to a private school. A few years ago, when she was probably 6, there was a problem at school that she had with a teacher. And because I am a product of my own socialization in my past, I asked her what had happened, and I was quite keen to know whether the person responsible for her discontent was white or black, because in my mind, race may have had an issue. And so I asked of this young innocent child, was the teacher white or black? And she replied beautifully and honestly, no, Granddad, she was peach. And so she didn't see black or white. She saw the peach complexion of a teacher, and that was her answer. And so moving away from race, I want to say, though, on the other hand, we have made considerable strides in becoming a more inclusive society. Through legislation and litigation, we have advanced the idea that difference is valued and recognized, and that the idea of equality is not about ensuring that those who are like us should be entitled to the benefits and rights we have, but importantly, that those who are different from us are entitled to the same protection of the law and the opportunity to be who they are. Landmark judgments dealing with the rights of gays and lesbians, women, children, non-nationals, cultural and religious groups, they have all advanced the idea of an inclusive society. A Rastafarian child going to school wearing his dreadlocks proudly, or a Jewish boy proudly donning his kippah, I hope the pronunciation is right, an Indian girl wearing a nose ring to school, a Malay woman wearing a headscarf to complement her work uniform in the Department of Correctional Services, or a Zulu hotel receptionist proudly displaying his isipandla on his wrist, have become part of how we encourage and celebrate the diversity of who we are. These may not seem significant in the bigger scheme of things, but human identity, self-determination, and self-expression is such an integral part of human dignity. South Africa has done remarkably well as we observe how other societies fight to impose uniformity as part of a dominant culture to their great detriment. And in this regard, the idea of cultural liberty has been recognized as an important component of human development. The 2004 UNDP report, on which I was privileged to work, says the following about cultural liberty. It says cultural liberty is a vital part of human development, because being able to choose one's identity, who one is, without losing the respect of others or being excluded from other choices is important in leading a full life. People want the freedom to practice their religion openly, to speak their language, to celebrate their ethnic or religious heritage without fear of ridicule or punishment or diminished opportunity. People want the freedom to participate in society without having to slip off their chosen cultural moorings. It concludes by saying it is a simple idea, but profoundly unsettling. I imagine the unsettling part of it is that even as we support and encourage cultural liberty, we need to be careful that it doesn't lead to the balkanization of our society, because the idea really in celebrating difference is not to forget that there are more things that we share in common than things that separate us. And so the Constitution has been a truly powerful instrument, both in its commitment to and the realization of an inclusive society. But there are other areas, however, in the quest to be more inclusive, where we have not been as successful. The exclusion of the millions of poor people living in poverty, the neglect of language, the slow development in the inclusion of the values of customary law, not as an insulated part of our law, but as part of the new constitutional order, are just some of them. I think in this regard of our little progress we have made in embracing the humanistic value of Ubuntu, just not as part of our social practice, but as a central value in our legal system, to regulate concepts of fairness in contract, sentencing within the criminal justice system, to support the greater use of mediation as opposed to an adversarial system of dispute resolution, which we currently favor, and really in the broad terms in how we respond to those who have breached the rules of society. One has a sense that this concept of Ubuntu, of which we speak about so regularly and so glibly, has been prominent by its absence in our legal order. And so there is much that can happen on that front to render our legal system just not more legitimate, but also to align it with the values of our Constitution, including those of social and redistributive justice. It must happen in law reform, in the activism of lawyers and judges, in the strong and well-researched voices of academia, and in the public reasoning of our people. And so much for the idea of a united South Africa, united in its diversity. The next issue really is that of a government that is open, accountable, and responsive. And I think the kind of government the Constitution contemplated and the relationship between it and its people was likely to take center stage as it has done for the past 25 years. The Constitution speaks of an open, accountable, transparent, and responsive government. And I think from a legal perspective, much has happened to give effect to that vision. Laws such as the Promotion of Access to Information Act, the Promotion of Just Administrative Action Act, the Public Finance Management Act, and other such laws have advanced the idea of open, transparent, and accountable government. Institutionally, the establishment of independent Chapter 9 institutions such as the Human Rights Commission, the Public Protector, the Auditor General, Parliament and its oversight role have all contributed to a system of greater openness, accountability, and where government is expected to justify the use of the power at its disposal. And here one is reminded of the timeless and eloquent articulation of that concept by the late Professor Etienne Morenik in his characterization of the interim constitution when he said, and I quote, "If the constitution is a bridge away from a culture of authority, it is clear what it must be a bridge to. It must lead to a culture of justification, a culture in which every exercise of power is expected to be justified, a culture in which the leadership given by government rests on the cogency of the case offered in defense of its decisions, and not the fear inspired by the force at its command. The new order must be a community built on persuasion, not coercion." In the past 25 years, there have been periods when that ideal has been held high and shaped governance, but there have also been dark periods where there have been attempts to relegate the notion of an accountable government to an insignificant principle. But even in these dark periods, the vigilance of civil society and the public at large has seen significant judgments to ensure that the principle of justification does not lose center place, And credit must go in this regard as well to government in observing court orders, even when they were on the wrong side of such orders or opposed them being granted. How the rule of law has become a significant feature in regulating power has also been remarkable. The principle of legality, the notions of both procedural and substantive fairness, and the concept of rationality have all contributed not to the idea that government must be restrained, but rather to the uncontested principle that power must be lawfully exercised. Some would point out that many of the matters that have come before our courts may have triggered the principle of the separation of powers, and these in turn have led to accusations of judicial overreach or a system of judicial supremacy. Former President Mbeki, writing on 25 years of the Constitution earlier this year, reminded us of the ANC's submission to the Constitutional Assembly in 1995 on this very issue. And this is what the ruling party had said to the Constitutional Assembly, and I quote, "Both the Constitution and the Bill of Rights must remain supreme. The South African state should have the character of being a democratic constitutional state, expressing the balance between democratism and constitutionalism." He went on to say, "The supremacy of the Constitution should not be a system against the state, but it should be a system for the democratic state, to guard against the state degenerating into anarchy, arbitrariness, and illegality without a framework of rules. Such a state would undermine democracy and democratic practices." In the same submission, the ruling party also accepted the centrality of and the necessity of the judicial role in the system of constitutional supremacy. On the other hand, on the topic of open, transparent, and responsive government, we have been sharply reminded of how easy it is to subvert that system. The work of the Zondo Commission has given us some insight into how even the best systems and frameworks can be thwarted, and how culture of greed and coercion could so easily set in when deployed by those who hold the power. In this regard, South Africans were shocked with the nature of the evidence that unfolded. And while the Commission has still to bring out its report, it is clear that the level and the scope and extent of corruption has dealt a serious hammer blow to the aspirations of the democratic state. One hopes we are able to turn the corner on that issue, but it reminds us of the relationship of power and rights. And in this regard, the late Professor Richard Falk, speaking on the relationship between power and rights, his words ring absolutely true when he said, "The power of rights, although a much more potent reality than would have been seemed likely a century ago, is still no match for the rights of power in a variety of settings," close quotes. And maybe that's a sharp reminder that constitutions and Bill of Rights do not exist and are expected to give effect to in a vacuum. They exist in context and within the contours of a world and a nation state where power is disproportionately held by some to the exclusion of others, and that continues so often to be a defining factor in the struggle and contestations of ordinary people. And so in a rights and a rules-based society, there is the perception that those who know the rules, as opposed to those who do not know them, those who are able to invoke the rules, as opposed to those who cannot do so, and those who have the resources to use the rules, as opposed to those who do not, have the clear advantage and invariably end up on the top of the heap. This should not be so if rights are meant to be universal. Finally, Prof, I'd like to speak to the issue of human rights and the challenges of poverty and inequality. Universally acclaimed, our Bill of Rights, with its extensive provisions covering just not classic civil and political rights, but also a strong commitment to social and economic rights within a framework of advancing social justice, was held up as the terms and the scope of the promissory note made in the Constitution for a better life for all. Mindful that the transition to democracy was not accompanied by any change other than political, and that economic and social landscape remained unchanged, at least immediately after April 1994, the Bill of Rights assumed even greater significance. While there has no doubt been much that is worthy of celebration on this front, including most of the civil and political rights, such as the right to vote, the right to association, to free and independent media, to equality before the law, in other areas, and in particular in the improvement of the material conditions under which people live, progress has been much slower. The 2011 Diagnostic Report of the National Planning Commission, in its diagnostic overview, identified a number of challenges, and they included: 1, too few Africans are employed; 2, the quality of education for poor Black South Africans is substandard; 3, spatial challenges marginalize the poor; 4, the ailing public health system confronts a massive disease burden; and 5, South Africa remains a divided society. I would imagine this diagnosis existed in 1994. It was made by the Planning Commission in 2011, and some 10 years later, I imagine the same diagnosis continues to hold true. And so while there has been much done, at least quantitatively, in terms of housing, water, sanitation, and other areas meant to improve the quality of life, much has been lacking, in particular in terms of quality and sustainability. Education and healthcare provide prime examples of that, where despite an increase in the number of people being reached and the resources allocated, the quality of what is provided remains problematic. There are also debates in the context of the justiciability of social economic rights that courts have been legally conservative, and traditional South African legal culture has constrained the transformative project. While on the other hand, others point out that while courts must play a leading role in this area, they are required to act with restraint, mindful of the limits of their judicial power, and cannot and should not play the leading role. These are interesting positions which are not unreconcilable, and I think it must be accepted that there is scope for greater judicial activism in this regard, while respecting the boundaries of judicial power. If we are to give effect to the Constitution, then while the court is not the primary locus of policy making, it is incumbent upon the court to ensure that the rights that are guaranteed in the Bill of Rights are given effect to, and when they are not, that courts are able to fashion effective remedies in terms of the boundaries of their judicial power, and certainly this is possible. And so I'm also concerned that in the area of human rights, we have seen what I call a commodification of rights, and a divided South Africa continuing to remain divided. And let me explain that. There are two systems that exist side by side, a public system and a private system. In the private system, people are able to buy their human rights: education, healthcare, housing, social security, safety and security, and even equality before the law are able to be acquired in accordance with the means available, while others are forced to rely on a public system and on the state to provide these two parallel systems that deliver common public goods, which are qualitatively vastly different, undermines the idea of a united South Africa. And so I often ask myself, the idea that we are all equal before the law is tested daily in the work I do. People who face the risk of the loss of their homes or their livelihoods are not able to invoke the protection of the law because they do not have the resources to do so, while others can litigate in defense of matters that may be regarded as trivial in the bigger scheme of things. The promise of equality before the law rings hollow in such circumstances. And it is cold comfort to someone who has lost their home to be reminded that indeed they are equal before the law. It's hardly the idea of an egalitarian society, and it's likely to entrench the idea of a divided South Africa, as the Planning Commission observed in its 2001 report. Finally, just a few words, Chair, on the courts. I think there's been a fair amount of attack on the judiciary, with accusations of judicial overreach and sometimes even of a judicial dictatorship. And simply, rather than just dismissing these as unsubstantiated, it's important to locate that discussion in its proper context. Section 172 of the Constitution requires that courts have the obligation the point I was simply making is that the judiciary is obliged and courts are obliged to declare law or conduct that is inconsistent with the Constitution unconstitutional to the extent of that inconsistency. And courts attempt to work within this framework, but by force they would have to review the conduct of the executive and the legislature. They do not do so because they regard themselves as the supreme institution. The Constitution is supreme. They do so because they're enjoined by the Constitution to do so. And so I think as a sitting judge, and I'm not making the argument that somehow the judiciary must be immune from criticism. We live in an open society where frank and robust and honest debate and discussion is necessary for us to thrive. But I think all that we ask is that when charges of corruption and partisanship and playing politics are made, then at the very least, those who make them and those who level them should provide some basis for their justification. And so in conclusion, Chair, I think if one looks back at the last 25 years, then clearly the Constitution has worked in many respects. In other respects, its promise remains unfulfilled. And it's important that that should be a matter of concern, because too many people live outside of the Constitution. They are yet to feel its reach. They are yet to experience the reality of its promise. And it's somewhat of a shame that we find ourselves in this situation. I often ask myself that today it's very difficult for South Africans to answer the question, how did the society allow an abhorrent system such as apartheid to survive and indeed thrive for so long? And there really is no answer to that. No one is able to give such an answer. I wonder if those of us who live in this society today are asked this question in a few years to come. How did this society that was born on a commitment of equality, that was ushered in on the back of perhaps the most progressive constitution in the world, allow itself to remain consistently the most unequal society in the world with such deep levels of poverty? What will our answer be? I'm not sure what it will be. And therein lies the challenge, because the fragility of the democracy we've put in place will always be threatened by the deep social inequalities that exist in our society. So if we address it, and even if we address it for selfish reasons, we need to address it. But as Arthur Chaskelson, late Chief Justice, reminded us, this is something that we must do, just not because it's the right thing to do, but also because it's the ethical thing to do. And for us to do that means that we must be willing to change the way in which we live. As Mahatma Gandhi said, the rich must learn to live more simply so that the poor can simply live. Chair, I think I've gone perhaps over my time, and partly due to the interruptions, but I'll stop there. Thank you. And I hope we have a connection if there are any questions. Thank you.
Thanks, Judge. Thank you very much for this wonderful lecture. Very incisive. You've managed to cover this huge field for that has spanned almost 3 decades now in a space of less than an hour, which is quite impressive, and a huge challenge that you have managed to overcome here. There are already 3 questions I can see in the chat. I do have my own comments on this, but I would prefer to start with the questions. If the questioners are able to, I'll ask them to put on their mic and then even the camera if they can, and then ask. I'll start with Professor Hugh Corder. You answer the questions, Judge, after the 3 questions have been posed.
Will do.
Then we'll take another round. Professor Corder first. He's not joining, but he says, wonderful exposition. Thank you, Judge. One question on which you touched. He says, we're too ambitious. Okay, were we too ambitious in those heady days of 1994-96? Perhaps just one example or none. That's the question.
You muted, Dean.
Sorry. Did you hear Professor Corder's one? Or else?
Yes, I did hear the question. Thank you.
Mongwai Kikana, are you able to ask this question, or should I ask it for you?
If you would ask the question, please, Dean.
Okay. He says, do you think that Section 172 is sufficient power for the judiciary? The third question is from our colleague Salona Lachman, who says, thank you, Justice Kollapen, for your thoughtful presentation. I'm a lecturer in human rights law. I value your comments on race and inequality. It is very difficult to teach students about the value of human rights instruments when they see entrenched poverty and inequality. They are often very critical of these instruments. What drives you to remain positive about the value of these instruments?
Good. Thank you, Prof. I'll try and deal with those 3 questions. To Professor Yukoda's question, I think the answer is yes. We were probably too ambitious in 1994 and 96. But I suppose the response to that is that we couldn't have been anything other than as ambitious as we were because of the nature of the transition. You will recall that there was a change in political power, but nothing else. And so what was to be offered to the millions of South Africans who waited for 350 years for this change? The offer was in the promise of the Constitution, and therefore setting the bar as high as it did was in part the outcome of that process. But I may agree with Professor Corder that in some areas we may have gone too far. So, access to information. I think we were one of the first societies in the world to provide for access to privately held information. And so we put in place this very sophisticated constitution without paying due regard to the kind of administration that would be required to sustain and support it. And that comes back to bite us in many ways. So we undertake to process social grants within 90 days, but we were unable to do so because we set the bar as high as we did. But the difficulty, Prof, is that we can't lower the bar now. We've set it there. And I still think we're capable of reaching much of those ambitious goals we set. We have simply just not done as well as we should have. To Mr. Mangwai Kekana, I think it's important to look at the scope of 172 in terms of judicial power. 172 is there to ensure that the supremacy of the Constitution principle is maintained. It's not about the quantification of judicial power. And that's the mechanism and the regulating mechanism by which courts can ensure that other arms of government are accountable, not to the courts, but to the Constitution. So the courts are obliged to strike down law conduct that is inconsistent, but it doesn't go beyond that. And I think if it went beyond that, there would be the real risk of breaching the principle of separation. And finally, to Ms. Lachman, well, I think, it's 70 years since the Universal Declaration of Human Rights, 73 years, and the world is still an unequal place. But at the same time, we are able to locate much progress within those instruments. The mere ability to get a vastly diverse international community to agree on a convention for the rights of people with disabilities is remarkable in itself. So those instruments are important as a framework. It's how we move beyond them. And I think one of the points I was wanting to make, but didn't, is that the fundamental structure of our society is problematic. And so these wonderful instruments will always fall short of achieving their potential until we deal with the structural fault lines in our society. If we continue to function within the existing structures and the existing inequalities, there will be some incremental progress, but we will never attain the kind of standard of living for our people that they deserve. And so your question is, why do I still keep faith in those instruments? Well, I think that's the answer. They provide a basis, they provide a core. Tomorrow I'm doing a lecture to judges from across Africa on refugee law. And the OAU Refugee Convention, for example, is an important framework representing the collective will, at least of the political leadership. And that is a basis from which one can move forward. But I agree, one should not be too excited about these instruments either.
Thanks, Judge. I have 4 more questions, and these are the last we'll take. The first is from Chumani. He's asking, what do you think about how the courts handled the fees must fall, roads must fall movement? I don't know whether you remember all the cases that went to court, but he's asking a general question. If you can answer that, we would appreciate. The second is from Bekezeli Benjamin, our colleague in the faculty, who is thanking you for the illuminating talk, and he's asking, his question goes as this. I mean, while the Constitution grants judges searching powers of review, there is a school of thought that argues that sometimes judges do so or exercise this power in an unprincipled manner or inconsistently. For example, the Gauteng judgment setting aside the lockdown rules. How do you see this criticism? How do judges in general view this criticism, and how could they better perform their judicial functions? The third question is from Siabulela May. He says, okay, he or she says, the JSC reported an increase on the complaints against Constitutional Court judges. This might have an impact on how the court is viewed by society, and perhaps put across a message that judges can do as they wish and get away with it. In your view, what impact does this have on our courts and also in building trust in the Constitutional Court? The question have become 5 now. So the Reginald Chabalala says, thank you, Judge, for a wonderful presentation. One of the things that I'll read this, I believe will improve equality before the law is legal certainty. So consistent application of the law from the lower courts. How does a litigant at the lowest court acting in person become assured of consistent application of the law? The last question is from a colleague, Norina Ali. She thanks you for the presentation, and she notes that you have noted the role of judicial activism, however, given the depth of state failure and incapacity that we currently face, to what extent can courts effectively respond to those challenges? She says that courts have demonstrated willingness to embrace robust remedies, but in the absence of responsive actors, these may ultimately remain blunt. So 5 questions, Judge. Yeah, those are the last ones. Thanks.
Okay, thank you. I'm not sure if I've followed and understood the first question in the detail around the fees must fall and how courts dealt with it. But I'd like to say that if the idea that this is a society that would free the potential of each person, I mean, that's the only hope that's offered to young people. We will free your potential, nothing else. And how do you free that potential? You free it through providing education. If you don't provide that education, the prospect of freeing that potential is killed. And so some will have their potential freed because they can afford a good education and others will not. So I think, firstly, one must locate that debate in its proper historical and constitutional context. And if one did that, maybe there would be greater understanding of what the Fees Must Fall campaign is about, what it seeks to do, and how it is in fact aligned with the vision of the Constitution. I don't want to talk about some of the features of that campaign and how it manifested itself, and that's the subject of some discussion. I don't want to also be critical of or praise the judgments of my colleagues, but I simply wish to respond by saying that if one locates that campaign in its proper context, there should be a societal and judicial understanding of where it is and what it seeks to do, without being distracted by, let's say, the sideshows that may have accompanied some features of that campaign and that we were all privy to, without losing sight of the core of that campaign. The second question is on review, and clearly the idea of the powers of a court in a review is clearly circumscribed. The court determines questions of legality, rationality, procedural fairness, and so the Constitution and PAJA provide that framework where court, and it's quite a low bar for government to meet the test of rationality, to meet the test of legality, sets the bar quite low. And indeed, the provisions of PAJA don't require too much of government in terms of capacity. Courts have been quite clear in articulating that our role is not to determine that if government had a series of choices, which was the better choice. If I as a judge would have chosen number 2 instead of number 3, that's not the basis for me to intervene. And courts have been quite clear on that. They would only interfere where, for example, the principle of legality is breached, where rationality or where some grounds in terms of PAJA have been properly triggered and a proper case has been made out. Where courts have gone beyond that, then there is the correcting mechanism of an appeal court. But when courts do that, it's not part of a concerted campaign of courts wanting to accumulate. Different judges may see matters differently. And I can assure you, sitting where I sit, it's not part of a desire to become a super institution. Judges do make mistakes, have done so in the past and will continue to do so in the future. But I don't think one should be alarmed by that. The fourth question is regarding complaints. And I think the fact that there are complaints, on the one hand, suggests that the courts are held in high esteem, but they're not beyond criticism. And it may well be that as people recognize these courts as an integral part of the system, they expect courts to function in the way in which the Constitution requires. I'm not sure what the content of those complaints are. It'd be interesting. I know there's a large number of complaints that go in, and I've been on the wrong side of some complaints, but many of those complaints is really about a litigant being unhappy with a decision I'd made. I'd say if the complaint was about judicial conduct and whether a judge treated someone with dignity, those are serious matters. So without knowing the content of the complaint, I wouldn't say that's bad or good for the Constitutional Court. I think what is important is for those complaints to be dealt with expeditiously, and I emphasize expeditiously, and for the public to be privy to what those complaints were, and for a resolution on those complaints. And if there's a need for any remedial action, then so be it. We have seen in the recent past that judges are also human. We've seen that they err, just not in their judicial function, but at a personal level. It's not good for the judiciary, but I think we have reached the maturity as a society to be able to talk openly about that and say, well, that's a reflection of a poor conduct on the part of a judge, judicial or otherwise, and we need to deal with it. I think one of the problems, Chair, is that the long delay in dealing with complaints of judicial misconduct may reinforce in the public a notion that there is a lack of accountability. If it takes so many years, then for some people might feel judges have a different standard of justice and fairness when it comes to complaints involving them. And so expeditious finalizing of complaints is important. The fourth question is about equality before the law. And I think this poses a real challenge to judges. And I find myself in that situation quite often, where you have an unrepresented litigant up against somebody who's resourced and who knows the law. There have been cases, though, where unrepresented litigants have done remarkably well. But in the main, they are at a disadvantage because they don't know the rules of the game. And it creates quite a challenge for one as a judge, because your job is to find a resolution that accords with the law and that is just as well. And sometimes something that accords with the law may not necessarily be just. And I've, at a personal level, found that the idea of stepping into the arena becomes problematic, because unless you step into the arena, you're not going to advance the notion of ensuring that that unrepresented person has a fair shot at getting a verdict in her favor. But when you step into the arena, you're mindful that you may be breaching what is expected of a judge. So you sit in the squandary. And I don't think the problem should then be that of the presiding officer. I think the system needs to look at these matters. And I certainly think that ideas like community service for law graduates, mandatory pro bono work for attorneys and advocates will go a long way to ensuring that that large body of people who are unable to get representation can at least have their day in court, and the idea of equality before the law can become meaningful. But it's a serious problem, as I've said in my lecture, that someone could lose their house without being able to be represented, but someone else could bring an application to court to say, well, you built a house that blocks my view of the ocean. It gives you just an idea of how disparate a society we are. And then finally, in response to Ms. Ali's question, I suppose the answer to that is that you would have a constitutional crisis if the courts went even beyond where they're going now. Courts would grant remedies. Then you had the development of what is called a structural interdict, where courts, wary of whether the orders would be implemented, would require government to report back within periodic periods on what they've done. The mechanism of contempt has been of limited value. But beyond that, I think you disrupt the entire constitutional design if one went beyond that, and you would have a constitutional crisis. Ultimately, in a democracy, the principle of separation works effectively when everybody else does their work. When others don't do their work, the principle of separation comes under threat, because there's a greater pressure on the court to remedy the shortcomings in other arms of government, which goes beyond declaring something unconstitutional or not. It goes to the actual implementation of programs and policies, which is not the work of the courts, but it's in that process that, on the one hand, you need an effective remedy, and on the other hand, you're constrained by the limits of your judicial power. Yeah.
Thank you very much, Judge, for answering all these questions, but also for the lecture, the substantive lecture that you have shared with us, you have given us. There were challenges, but it was worth the wait. I know that Gabby struggled to find time for you because you were quite busy, and finally here we are. What remains now is to find the space, most likely next year, for you to come and have interactions with faculty and students. I deeply appreciate the lecture that you have given. I thoroughly enjoyed it. It's critical issues that are being discussed here everybody is frustrated about developments, especially constitutional developments. It's harder now to teach constitutional law than it was 20 years ago, 15, even 15 years ago, when the Constitution seemed to have this binding power that held us all together and the institutions together. It was guiding us. Now all that binding force seems to be loosening and quite fast. And so everybody, when they look forward, you wonder what will become of this Constitution. Will it completely fail? And so it's worth to discuss and debate these issues in the hope that we can find solutions to our challenges that we have. I would like also to thank once again the Rabinowitz family, especially Mr. Reni Rabinowitz himself and his daughters who are with us here. Special thanks also to Gabi Ricci and also our colleagues Nurina Ali and Solona Lachman, who played the role of organizing this event and making it possible this year under these very difficult circumstances. I would like to thank the audience, colleagues, alumni, and all friends of the faculty who joined this event, and for the questions, the people who have raised specific questions in the chat, which you have answered them all. Thank you once again, and hope to see you next year, Judge.
Thank you, Prof. And I enjoyed the time there. And I'm sorry about the technical hitches, but we managed to get through it. So
it's part of our life now. Yeah.
Okay.
Thank you very much, colleagues. Bye-bye.
Okay, good night. Good night.